am a board member of IWC. I again want to thank you all for joining us today. It's so great to see some familiar faces, some faces I've only seen on Zoom, and some new faces here. So thanks again, and if you're not a member, we certainly hope that you become a member after today's wonderful conference. So I think we all listened to that amazing last panel on advocacy and the importance to get laws passed. And so this panel is about compliance. I know we all probably hate to even talk about compliance, but compliance is after those laws are passed and the regulations are made, it's interpreting those regulations, and whether or not you're an operator or you have a business that is supporting the cannabis industry, the need to understand the seriousness of compliance is really crucial. And so to lead us in today's discussion, I've got Florence Hardy. She is a seasoned attorney, graduate from John Marshall. Don't hold that against her, not Kent, but another great law school here in Chicago. And her mantra is cannabis is all about contracts, capital, and compliance. So enough from me, and I will lead you to Florence.
Hi, everyone. Nafira did such a great job. I hope I can hold a candle to her moderating abilities. But I'd like to thank you for joining us today on this conversation on compliance. As an attorney, and all of the attorneys on the panel know, compliance is success or failure in this industry. So let me go ahead and introduce our panel today. So first, all the way to my left, we have Ryan Holz. He is a partner in the cannabis law practice at Greenspoon, Marder, LLP. He advises clients on complex legal and business issues impacting cannabis-related businesses. He actively represents cannabis, hemp, and CBD clients in Illinois on topics ranging from licensing issues, regulatory compliance, policies and procedures, and general business concerns. He has a comprehensive understanding of the cannabis laws in the U.S. and provides his clients with timely federal, state, and local developments. Thank you for joining us. Immediately next to Ryan, we have Dahmann. Kristin is a senior associate at Ice Miller's Litigation and Cannabis Industry Group. Kristina, right?
Yes.
Kristina, I'm sorry, my notes were wrong. Kristina has a broad litigation experience encompassing traditional business and banking disputes, trade secret protection, and white-collar criminal defense. She has specific experience with comprehensive compliance reviews, training programs, and federal and state administrative and regulatory processes with respect to federal and state regulated industries. So thank you for joining us, Kristina. And then last but not least, we have Joanne Caceres. Joanne counsels clients in the cannabis industry to attain their business objectives while avoiding legal risk in this rapidly evolving regulatory environment. This includes advocating full times for clients in and impacted by state legal cannabis industries and tensions with federal law. Current clients include large publicly traded companies selling products or services into the cannabis industry, companies involved in financing the industry, vaporizer manufacturers, and a company operating dispensaries in several states. Thank you for joining us, Joanne. So as was mentioned, compliance is key to success in the cannabis industry, specifically because this is a federally illegal industry that we're operating in. So I'll begin with the first question. For all of the panelists, can you talk about your approach to compliance and how you determine what process a client should take when developing their compliance practices?
I'll start. Can you guys hear me? That's good. Okay, great. I think the best analogy I like to always talk about is think about like your doctor, right? Really the best way to work with your doctor is to go for that annual checkup and catch issues before you start do the preventative stuff, right? Because you don't want to see your doctor for the first time when you have a huge problem. Same thing here with law and compliance. You want to get in there before the problem happens, because at that point it's a lot cheaper and easier to fix than it is at the end of the day, right? As outside counsel, hopefully, we see most of the worst things, right? But hopefully you have someone internal that is going to catch all the smaller things at the beginning. So it really is, compliance is just something that you have to look at all the time, and it's way better to do it on the front end than the back end, right? So think of us like your doctors. If you take nothing else, think of us as your doctors. Don't lie to us. We're part of the industry. We want it to succeed. We understand there might be strategic reasons you don't want to follow all the regs, and we can kind of help figure out where those lines are. And we can also help figure out where those lines aren't, right? Like, there are certain times where I say, you cannot do this. Because if you do this, this is what's going to happen. There are other times where it's like, the law's really not clear. So, maybe this is an ask for forgiveness type of situation. So, yeah, if there's one thing I'll say now and I'll move on is, we're your friends. We're your business friends, I guess. We're here to help you, and don't lie to us, right? Just tell us the truth. Tell us what you're doing. Tell us what the problem is. We're going to work with you for your best solution, hopefully on the right side of the law.
Yeah, 2 points actually to piggyback on that. One, as your doctor, you have a patient-doctor confidentiality. You have the same sort of confidentiality with your lawyers. And that's really, really helpful because we can help guide on those lines. And we can also help guide when the line needs to move and interface with regulators to explain why the line that they've drawn makes no sense. And one of the kind of key components that we always stress is to make sure that you have great relationships with regulators, both from the state level as well as in the local level, because the people on the local level will be able to have a stronger voice with the state level when there's certain aspects of your business that needs to change that they support. And that's an approach that we always take, is to have not only you have vertical integration or vertical conversations within the state, but also then horizontal within your own company, so you have communication structures about what's working and what's not working. So my 3 pillars in terms of compliance is... You gotta turn the mic off. Oh, but I have a general 3 pillars approach to compliance. It's a policy, it's a procedure, and then training. The policy is very high level. Those are the bright line rules that are not going to change because they're harder to adapt in the long term. And those policies, though, will trickle down into your procedures and into your training. The procedures are what you have at each level of your operation and what people are going to look to for day-to-day operational needs. And those are often promulgated and included in your application for your license. So you have a good benchmark for purposes of those procedures from day one. And I take that to heart because my practice started in Ohio when Ohio legalized medical marijuana, and I was one of the first outside counsel hired to actually write procedures for purposes of those applications, and then to defend those procedures when the board said that the Department of Commerce said that the procedures supplied did not meet the regulations. But the procedures are very important because those will be the guideposts for your operations. But those will need to change from time to time as the regulations change or as the regulators decide that the interpretation that they originally took isn't exactly what they want to see happening, or you realize what they had in the original regulation doesn't make sense and it needs to change. And then the third part is training. That's making sure that the people that are on the ground know how to work with those procedures and in order to achieve those original policies. And training, it can be a great tool as well when there is something that has gone incorrectly, because you can show the regulators that you have done the due diligence to make sure that everybody has been informed and that there just was a mistake made or something wasn't complied with on a one-off instance, as opposed to something that the company isn't doing on a day-to-day basis.
Yeah, no, those are all great comments. There, it's working, okay. The one thing I'd add, as relevant to a lot of people in this room, is there's an inherent contradiction with compliance, especially for startup entities, in that compliance does have some costs. Creating policies, creating procedures, making the training aspects of them are difficult. They're not easy to do. They do cost time, they do cost money, and for a lot of startup entities, those are in short supply. And so there's got to be a balance between, companies need to look for a balance, but they shouldn't shortchange the compliance aspect too much. And so one thing I like to advise, just be there for clients at the front end. Let's hit the big big picture items right away. Let's make sure we have some policies and procedures. Let's make sure we have something. We can be cognizant of the financial ramifications to you as a company, especially a startup company. And like Joanne said, there are some things that are cut and dry. You cannot do X. So let's knock out that and make sure we're compliant on X, whereas Y is a little bit grayer. And so I think it's worth the time and effort, and we'll talk about this a little later, the way compliance issues, if not done right on the front end, can have ramifications beyond what even you would think would be the case, which is regulatory problems. They can have big impacts on sales going forward and whatnot. So I'd say come to us and say, look, here's where I'm at. Here's my financial situation. I can't spend $700 an hour you creating a compliance plan for me, but can we talk through what I need to do to get myself up and running and started? And I think that's a big issue that a lot of companies look at compliance and say, I'll do it later. Think about that on the front end before you start operations, because it's hugely important.
Yeah.
Thank you all for your responses. And building off what you alluded to, Ryan, as well as Joanne, I'd like to get your input on when is outside counsel a good decision for a cannabis company versus hiring maybe a compliance officer in-house. What are some of the situations that you see where one works better than the other, or maybe a combination of both is best?
Yeah, a combination of both is always going to be best. But yeah, I would say as soon as you can afford that compliance officer, that's when you should get them, right? Because just the way these fees can rack up is no joke. So I'll give you IDFPR as an example. They're the agency that regulates dispensaries, right? They go in and they do an inspection. Every tiny thing they find, 2, 3K, 5K, they add them all up, you got a 20K bill that day, right? So that's already what, a third, a fourth of a full year's time salary of one person, So it really makes sense. You need that internal person. And as I think Ryan or Kristina were both mentioning, the importance of relationships with your regulators, that person is going to be the person that's going to get to know the regulators, build a relationship with them, be able to say, oh, this was an honest mistake, and the regulator will trust them because they know them, right? Now, when do you want outside counsel? When the shit has really hit the fan, right? Or when the state's telling you can't do something and it is bullshit, to use that term. Well, like for example, I had a client who had a brand, maybe some people know it, that has a little bull on it, right? And IDFPR came in and said, this is appealing to children, right? You might not want your compliance officer to get into a huge fight with the regulator about whether or not that makes any sense, but I can do it, right? I can call, I have my own relationship with them, so I'm not gonna, burn bridges. But it's just a lot easier as the outside person who's not part of the business to say, with all due respect, IDFPR, that position is effing ridiculous. Like, there's no way this bull is attractive to children. It's like a monogrammed silver bull, right? So there really is kind of like times when you want your internal person with the relationship who really knows your business and really knows what you're doing to be managing that, and it's obviously way more cost effective. And then you will only, hopefully I only hear from you when there's really a huge problem, right? And the fees that we charge are going to be worth it because we're going to hopefully save you from that 100K fine that they're talking about, right? So that's the balance that you try to strike. So yeah, as soon as you can afford that compliance officer, please get them. You don't need to be calling us for those tiny problems. Like, we'll spend 2K defending you from that 2K bill, right? So,
So I think that all makes a lot of sense. You will always want to have someone who is in charge of compliance from day one, even if they're going to then wear 4 or 5 different hats on day one. And what that does is it builds that framework for the growth that you'll anticipate having down the road. I also think there's a time for a good cop and a time for a bad cop. And I joke that I'm always the bad cop on our cannabis team because I have the litigation background. I'm going to tell you how it is and how it should be, and this is why. And I'll argue and advocate very strongly. But we have other people on our team, in our public affairs group, that have been working with regulators since day one of the program. And they are, I kid you not, best friends with the regulators. And I almost find that strange as a litigator because I'm like, why are you, having such close relationships with who I see at times as an adversary? And that's how, all compliance officers or the business in general should be with regulators. And I know that that's not always natural, but it's a great way to build that trust, because when there then is a problem, there may be a phone call that's made before you get the notice. Or the notice is made and you have time to comply, but the 4 days or whatever time frame they give you isn't sufficient and you need more time. You can ask for it and make sure that you can actually keep, the business running when you're doing what you need to do, but also correct it, because oftentimes there's a reason why they're having the rule be the way that the rule is, because we have to keep the government happy and the other politicians, and in particular in Ohio, happy that the program is going well and is successful, so that it can, one, expand, and two, grow from medical to recreational. Because if there's not a successful medical program, then there wouldn't be there will not be a recreational program.
Those are all great points. I think one of the best points there is it's nice to have a buffer when you're dealing with regulators. And the bad cop angle is the right one. You don't have to necessarily have an adversarial relationship, but there is a good way to have, it's easier for us to speak to a regulator in a way that maybe you don't want to. And so it's oftentimes very good to have even, basic emails about, compliance issues handled through a lawyer. It's very inexpensive to do that. You don't have to, we don't have to do a whole lot of work on that. I also think it's worthwhile to have a lawyer take a look at your plans. Kristina mentioned it. I think it's a great point. A lot of your policies and procedures are set forth in your application in most states. And in most states, if not all, you're bound by what you wrote in your application. And a lot of times, you're writing your application to be impressive, not necessarily to be operational. And so it's really important to make sure that your plans are consistent with both the law and consistent with what you plan to do in the operations. And so it's important to have someone look at them, especially if you wrote them yourselves or had a consultant without a legal background writing them. Those people do great jobs, but they're looking at it from a different perspective, which is, how am I going to get these points? How am I going to impress? Not whether it makes sense as an operational point. So, we like to look at those plans and say, okay, you might have an issue here. Can you really do this? Again, one of my best stories is, got a person in Florida. Well, we're gonna grow using all organic herbicides. In Florida, that's not that easy, especially in greenhouse grows. And the regulation didn't require you to use only organics, but the plan said it, and the law said you had to comply with your plan. So now you've crafted on or grafted on a non-legal requirement has become a legal requirement for you because you put it in your plan. And so those things we can catch, those things you can change often with a quick note to a regulator saying, look, we put this in our plan, things have changed on the ground, we're going to not do this, and you've avoided an issue. So.
That's a great story about how compliance can be looked at the forefront, right when you're applying. Can you talk about some of the other high-level compliance issues that you see, whether it be from a new company? I think we'll have a lot of applicants in the room, but we may have some who are already in business. What are some of the top compliance issues that you see and some ways to either address them or avoid them?
You want to go for it?
So I'll go back to that same story because the way that came out is a very interesting thing that a lot of people don't think of, and that's how pervasive compliance issues can be. You think about it often as you're going to deal with regulators. That's what it's going to be. You have a compliance problem, it's a regulatory problem, you're going to have to deal with the IDFPR, you might be fined. So this issue, again, started at the application stage. They put in there that they were going to use organic herbicides. They weren't going to do that. They didn't do that. 5 years down the line, they sell the company. In their reps and warranties in that sale, they said, I've complied with all applicable laws. A very common rep and warranty. A year later, the company that buys them, they have an issue, and they're looking for problems with this. And they come to us and say, you did not comply with all applicable laws. You used non-organic herbicides, and while that's legal, again, your application says you will not. Your application is binding. you've fundamentally misrepresented the scope of your operations, and we want to avoid this multiple $1 million sale. Client ended up prevailing on that for a lot of different reasons, but spent a whole lot of money after operating for 5 years under this premise. So compliance issues aren't just dealing with regulators on a day-to-day basis or dealing with fines. They can have wide consequences. Most people in this industry ultimately are going to get out in one way or another as we get consolidation via sales. And that rep and warranty that I've complied with all applicable laws or all material applicable laws is going to be in every sale agreement you write. And if you turn around and say, I'm striking that, then the other side's going to be, why? I mean, that's the biggest red flag of them all. So you're going to have to make that. And the way to make it truthfully is to get ahead of it on the front end. Make sure your application is in compliance. Make sure you've hit the big points of compliance on the front end and are continuing to do that throughout your operations.
So I think that there isn't really a one-size-fits-all for compliance issues, and I think that that speaks to the diversity in the industry, both from small shops to large shops, from mom and pop license holders to MSO license holders. We in Ohio, like here in Illinois, we have multiple regulators, and some regulators will be more stickler on certain items versus others. And that can be challenging if you are vertically integrated because you're trying to adapt and change your policies and procedures from one segment of the sector to a different segment of the sector. One of the largest problems that we've seen from license holders is the application and what's promised in the application versus what then you would deliver at the end of the day during your final inspection. There are some regulators in Ohio that will not let you change what's written in your application absent lots of sweat and work. And I'm speaking more on the Board of Pharmacy side than I am on the Department of Commerce side, and that speaks to the goals of those agencies.
Yeah, I'll just add one thing, and it kind of goes back to the last question too about like when is outside counsel useful. We have so many clients that we see a lot of the issues, right? So we might have seen something that's happening, a trend, that you won't be able to see because you're just your one business, right? So a good example right now that maybe will become applicable to some of you in the future is IDFPR takes this position that your floor plan that you've given them is the floor plan where you are allowed to do license activities. So in the winter, right, a lot of people have opened up like side lobbies or there's a place where you can whatever. IDFPR will be like, you cannot take orders in that space because it's not in your floor plan, which is like the craziest thing that you would think like, what is the big deal? But they've decided it's a big deal and they love fining you for it, right? So that's been something I've seen across multiple clients that like, even if you're like omnipresent, I don't know how you would know that that's like an issue, something that IDFPR is looking at. So I think that's another way that we can be helpful, and that's another example of something that you might not think of. You've already been doing this operation for like 3 years and you think you know all the rules and you're following them all, but there could be new things that IDFPR has started to look at that like they're focusing on at this moment, and then like we can kind of tell you that we see those things and you can kind of make sure before. I mean, it is really simple, right? You just have to shoot them a variance of your new floor plan and get permission for that, and then all of a sudden you're golden again, right? So that's another type of thing that you'll see is like something that wasn't a problem before all of a sudden is a problem now. So it's something you constantly have to be looking at. It's not like you can just set it and forget it.
I think that's a great point about not setting it and forget it, especially because the laws are changing, the rules are changing all the time. I think your statements that in-house compliance officer can help with that on a day-to-day basis is great. Are there any other best practices that cannabis companies can employ to sort of get ahead of those things that are not issues today? And so they haven't planned for them, but they have a method by which they can find them or seek them out before they become issues.
I think that's a great question, and it's one of those things where maybe 3 or 4 years ago, certainly in Ohio, it'd be like, gosh, already we're supposed to be worrying about those types of things. But now that most industries have matured in each state, I think we're at a point where we can do a little backwards looking to seeing what worked, what didn't work, so that we can do better moving forward. So one thing that we often recommend for our clients is to do an annual audit. You mentioned something about an annual checkup with your doctor. And what that does is it provides what I would call a more formal mechanism that you can tell regulators that you did, which is nice. You can get all at one time kind of the updates over the year and then implement those going forward, so you're not dealing with piecemeal updates on a day-to-day or week or monthly basis. You might end up needing to do updates, of course, but this is a way to do a check to make sure you've done everything you're supposed to do. And then ultimately, it can provide easy addendums so that when you do submit approval for those changes, that you're only doing it once. And it's easy to explain to the regulators that you're doing it because of this outside audit and you're checking these boxes and you want to make sure you do it. That's helpful on one license holder or one operation in one state. What do you do if you're in all 50 states or in 18 states? And when I say all 50 states, I'm thinking more on the hemp side than I am obviously on the cannabis side, or core cannabis, however you want to phrase it. With all 50 states, if you're operating and selling hemp products, that can be very challenging. Fortunately with that, regulators aren't as hard-hitting when it comes down to not meeting the regulatory requirements or getting all the required licenses. There's definitely an ability to play catch-up, at least currently. But we provide regular updates on a biannual basis to companies that are selling in all 50 states so that they can try to stay as compliant as possible. Because on the hemp side, it's a complete, you think core cannabis is difficult to follow, the hemp side is even more difficult because it isn't as defined and isn't as regulated, which can be great, but then also it means you can run into a lot of pitfalls.
I would say another big thing we haven't talked about is the culture of compliance, right? And it really comes from the top down, right? So have some sort of mechanism in place and make clear to each employee that compliance is important and compliance is part of their job, right? And have some mechanism where they can complain about something not compliant happening that's not directly to their manager or directly to the CEO, because a lot of times the person who doesn't want to do the compliant thing is actually the CEO, right? Like, they've got the bottom line and they're kind of on this track. So I've heard so many times of like, well, these employees knew this was an issue, but like, who's going to complain? Like, who can they complain to? The person that takes the issues is the person who told them to do this. So having those mechanisms, it could even be an anonymous email where people can send their issues, but like the people that are going to know best that you're not following the procedures are your employees that are following the procedures, right? So having that culture early on and making clear, like, yes, it can get really annoying, the person who's telling you that you're doing this wrong or that wrong, but making clear that that's important, even if it is harder to do, and to value that when an employee comes and tells you, hey, we're really, we're not actually doing the log right when we move from one room to another, right, or whatever it is, because a lot of times those things are really inconvenient to do. Having people feel empowered to tell you and to fix it is going to help so that you don't get to the situation when you have to call me and like 8 of your employees are going to tell me, oh yeah, we did this all the time and we all knew it was wrong, but what were we going to do about it? Give them something they can do about it.
Training.
Yeah.
Yeah, training is right. One of the CEOs we worked with would tell all his employees all the time, we are not in the cannabis business, we are in the compliance business. And that's really correct. We can all sit here and say whether or not cannabis is something that should be as highly regulated as it is.
Good point.
I certainly don't think it should be, given, but it is highly regulated, very highly regulated, and it is what it is. And so you are in the compliance business, at least, especially as these markets mature. And maybe 10 years from now, compliance won't be as big of an issue. But if you're starting up in Illinois, for instance, you are in the compliance business, first and foremost. And so, again, that culture of compliance is critical. And maybe separating, again, there is a bottom line component, and maybe separating, responsibility so that someone can be focused on compliance rather than the bottom line. And that person won't be popular all the time. It's just the way it is. But another thing to think about is, the law is constantly changing, and so you can come to us and say, look, I wish we were doing this, or I wish we could do this, and there are ways, and this goes back to the advocacy component of the previous panel. This is a developing market, and the regulators are learning too. And so if you've got issues, talk to your lawyer, and maybe 4 or 5 clients have this same issue, and maybe it doesn't make complete sense. And so there's ways to kind of work with regulators, and the last thing is the changes come out in a variety of different ways, right? You got statutes, you've got regulations, you have just kind of interpretations that you hear through the grapevine from a regulator. You know, that is, or, you know, there may be some gray areas. So there's a lot of different ways, and it's hard to keep up. So keeping an open line of communication with your compliance, either in-house or outside team, is critical to kind of stay up to date.
Thank you for that. And Joanne, you mentioned the floor plan issue with IDFPR, right? So it's not something that at the time of application you would have spent a lot of like time or effort on, because things change, right? Floor plans change all the time, specifically, right? Are there any regulations that you know about that the people in this audience should be mindful of? I know specifically there's these new HIPAA requirements that dispensaries need to know about. Is there anything like top of mind that if you don't do anything, make sure you focus on this new thing?
The floor plan for me is really the big one that I've seen. I was really surprised. Of like, you wouldn't necessarily think as a dispensary that you're responsible for the label being compliant. That's something the other side's supposed to do. But now we know, and we mention that to people when you accept packages, make sure you're looking at that kind of stuff too, because I mean, that fine was also ridiculous. It makes me really angry. Like, they literally were not expired. But yeah, you'll get dinged for something like that. So it's just, unfortunately, a lot of it's like you live and you learn, right? Like, you get dinged for something you weren't expecting, and then you know in the future to watch out for it.
Well, I think that's a great point. One thing that I don't ever want to have anyone that's downstream lose sight of is it's just like in any other industry where you have your person who's touching the plant in this instance, so you have the first square one of the supply chain, and then you have the retail, and there's someone in between, or multiple steps in between. But when you're on the retail side, you're responsible for selling a compliant product. And so that's where I think there's a lot of concern on our end with respect to the dispensaries, because they are selling the product that's supposed to be 100% compliant, but they're not the lab that's testing it. They're not the one that's processing it. They're not the one making the labels for it. And they're not the ones, obviously, ultimately, on day one, growing it. Oftentimes it is the same company because it's vertically integrated. And then you have assurances, and you can have comfort. Then your dispensaries are selling your own products. And that's where I think there's a lot of value in being vertically integrated, because you can take out risks. But that's obviously not everybody's, not everybody's there yet.
The clients is kind of what's the dividing line between processing, manufacturing, and infusing. I've had a lot of questions on that, because craft growers in Illinois and large-scale cultivators can do everything, but infusers are limited in what they can do. And what's that line between when are you infusing something or when are you manufacturing? Obviously, you cannot extract, but can you do some other things? Another issue I've seen come up is what kind of products can you make as an infuser? I actually had this issue with the IDFPR where they told me you couldn't vape. You couldn't make vape products. And they said because you can't make smokable products. And our response was pretty clear. I mean, if you look at the research, vaping is not, and smoking is combustion. By the definition, it's combustion. And vaping, by definition, is heating something right to the point before combustion and then turning it into a vape. And so we had a back and forth, because that was a huge issue, and all our plans said we're going to create vaping products. Rightfully so as an infuser, that's what's allowed. And I think we've prevailed on that, but I'm not positive yet. So,
All right. Well, we know what arguments.
yeah, right. I mean, but I mean that, and we got an email saying you cannot make vape products, and we're like, what? But you know, that's the kind of thing that's happening. So I've seen that issue pop up a lot.
So I think this will be our last question, and then I'll open it up, I think. I don't know if I can do that, but, you know, I'm up here and you're down there, so we'll see. And this is more of an opinion question. So I know we have some people who are in the process of applying, or they have applied, and there's this issue of separate entities, right? So breaking up the operation into your facilities, your HR, your accounting, et cetera. We know there's really no right answer. You might think there's a right answer, but there may not be a right answer to this. But what's your opinion on companies going that route as far as setting up their operation? Should they do one entity? Should they do multiple and report back or pay back or all those other things that are possible?
Is this when we do our typical disclaimer as an attorney? Yes. So we're not giving anyone
This
legal
is not
advice.
advice, okay? Do not follow the lead. This is not legal advice.
It's easy
Consult
when there's
your attorney.
PowerPoints. You have that at the very beginning.
Exactly. Not legal advice. You cannot come back and say, she told me to do it, okay? He told me to do it. That is not what's happening here, okay? There's just their opinion, maybe, okay? But not for you. Not for you. It's their opinion in their heads, okay.
I mean, I'm happy to take the first go at this. I think, there's really two sides of it. I think one is what's going to work for your business, and I think there's ways to get efficiencies by separating out various functions. But you run the risk of having those functions maintain control over the actual operator, the license holder. And so that's a fine line that you have to walk. Ultimately, I think when it's a fee for service, you're generally in a good position. But then that means really keeping separation between the different entities as opposed to having it be one company with different departments or a company that has those services that's then providing it to the various operators. In Ohio, it's a very clear line. It was a very clear line for a very long time, and it just got very muddy with the recent dispensary application process. They've put originally it was very clear that you're either an owner or you're not. And you're either managing and controlling or you're not. And now more recently, they've put together a set of factors that they're applying to determine whether there is someone that's controlling or not controlling. And that's a very hot issue right now and something that I have spent significant time as an outside counsel that's concerned with risk and risk mitigation for our clients. I like it because it's gray and it's mushy and you don't know and you're going to have to advocate down the road if there is an issue. But we also try to advise as best as possible to keep those lines separate.
Yeah, in a lot of ways it's more of a business question than a legal question, but I can say what I see a lot, and so there's probably a business reason people are doing it, is holding your real estate in one entity. And then holding your license and your operating business in a separate entity. I'm pretty sure 280E has something to do with that. There's some sort of tax advantage because you can maybe you can explain better because I don't really know the full reason why, but I just see that a lot and by a lot of our big clients, so I assume there's some pretty good reason they're doing it.
Yeah, that's exactly right. It is 280E. 280E allows you to take, or prevents you from taking certain deductions if you're a plant touching entity, and there's more nuance in that, but so that's why you do it. One of the countervailing points, though, is that it makes it more complicated. Mm-hmm. So, for instance, if you are dealing with investors who are, if you're a growing company and you're taking on investors and you have 4 or 5 separate entities, all with different valuations, we've had this come up. How do the investor wants to have a piece of this whole pie. They don't want just the real estate holding company or just, they're investing in the company. And how do you value those companies? How do you allocate the investment appropriately? So, there are countervailing concerns. If you're a more mature company, generating revenue in a lot of, large amounts of revenue, perhaps it does make sense to split them up and start trying to take advantage of the tax consequences. If you're an early stage company who's going to be taking in money on a regular basis, it may be easier to be a single company. That makes it less complicated, less legal work involved. So there is that balance, even though there might be a tax consequence to that.
Mm-hmm. It's funny, we haven't talked about accounting at all yet.
No.
And that's
on purpose.
Yeah. Yeah, when you're talking about the black sheep of compliance, no. As a lawyer, right, the joke is we don't do math. I mean, it's a lie because we do. But having a strong accounting department, I think in some of the big MSOs, that's one of their largest departments. And that's where I think we haven't also talked about like the banking and the compliance on that side. It'll keep you out of trouble, especially with the dichotomy between the federal government and the state governments. Generally, if you're staying compliant on the state level, the feds will stay out of your way. But if the money doesn't add up, that's when you're going to run into huge problems on a banking side, and that will just completely unravel if you're not careful. Unfortunately, we haven't had any clients that have had those problems, but in large part that's because they are partnering with financial institutions that work for them as much as you work for them by being their customer.
Thanks for that insight. That is, we did not talk about accounting on purpose. I do want to, we have Well, we don't, right? Oh, we have 2 minutes, yes. So, is there any, yes, questions from the audience?
So one of my key takeaways is that they're,
I think it's important to be aspirational because, again, you are trying to impress. You need a license first before you any of these problems. But it's also critical to recognize where you are being aspirational and be able to address it going forward. You do not want to be in a situation where you are very aspirational, but you don't realize that this is going above and beyond, and you could do better. And so the balance is, look, we all know you have to be aspirational in some respects to get a license, and you should be. I mean, this is a competition in a lot of states. Some states are different, but in a lot of states, it's you're being compared to everybody else. And what are you saying? So it's important. I don't say don't be aspirational. But I also say, know what you're doing, know the regulations, know where you are going above and beyond. And it's great. If you are going to go above and beyond them, great. That's fine. But there are ways to modify your application based on facts on the ground, and you need to be aware of them so that you can do it. If you just aren't paying attention to what your application says, that's when you get in trouble.
Okay. Ooh, I should do that. Okay, so I have 3 hands. I'm going to just go ahead. Okay, fantastic. These are the 3 questions that I'm going to ask. So if I didn't see your hand, so sad. So I'll start right here. So I'll repeat the question. Yeah, I'll repeat the question for recording purposes. The question was, how do you showcase experience in an industry where it's been illegal to operate previously?
So that's a great question. And as someone that was helping applicants in Ohio on day 1, we were struggling with how to do that. And really it came down to a few key pieces. One is there's crossover experiences. So when you're putting together who are your key people and you're bringing to your team, you need someone that can oversee operations. If it's a grow facility, someone that oversaw a farm or had some farming background. If it's a processing facility, it's someone that had been working in pharmaceuticals, that's been dealing with different forms of legal products that are then crossover skill sets that you can put into your application. And then there's all the other core pieces: security, compliance, accounting. Those are similar issues that are in many, many other industries. So you can have individuals that have had experience in those industries that you can demonstrate our crossover. That's really the best way, in my experience, to do that. Of course, partnering with someone that has already had experience in the industry is another key way to do so, because you can draw on their advice. They don't need to be the operator. They can be in a board. They can be in some sort of an advisory capacity that then ultimately can show that you have the depth and the strength and the bench to be able to be successful without having those people be the key person or even per se the owners, because you want to be able to lift up yourself or lift up the people that you're working with. And that's one thing I love about this industry, is there always are people that are willing to participate and help. And I think it's a good segue with the panel that we had earlier.
Yeah. Karshina, I'll go with you. Yeah.
I just have a question about the transfer associated with that.
Just so the question was transferability of licenses and how regulations allow or disallow that.
So transferring licenses is possible. If you are one of these social equity winners, it varies whether you have to pay a penalty or not, depending on the person that is buying, right? So if you are a social equity applicant and you're going to sell to another social equity applicant, that's totally fine in that first 5 years. If you're a social equity applicant selling to a non-social equity applicant in that first 5 years, there's a penalty. It's for the people that are going to be buying it, it's literally nothing. It's like, I think it adds up to $30K maybe in Illinois. Can vary by different states. But so that's one aspect of it. So it can be done with the dispensaries. There is a little bit of a twist where it's not until you have the actual license that it can be transferred. So your conditional licenses cannot be transferred. But of course we can contract that in a certain way. Usually these deals don't happen instantaneously anyway. There's a sign and a deposit, and then there's this long waiting period where you allow for the regulatory approval to happen, and then you actually close on it. So yeah, it's totally doable. I mean, definitely something you need a lawyer to help you do, but yeah, definitely. In some ways, buying is better because it's definite, right? You know exactly what it's going to cost and it's definite. Whereas like with the applications, you can spend like 400K and not win anything, right? So that's just one point. Did I address your question? Okay.
And the last question, gentleman with the glasses. So the question is a very good one.
Yeah.
So we have to stay compliant. Is there some way to ensure that the government stays compliant with what they've stated they will do?
They promise.
Yeah. I mean, in some ways, that would be
unfortunately.
yeah, that would have been
Yeah.
is a good question for the last panel, but
Right.
Yeah.
yeah, I think the big thing, the thing for accountability, right, is data, right? That's a big thing we need. I'm super curious. I want to know a year from now, how many of the licenses are still in the hands of social equity owners? Because I bet it's not going to be as high as we want it to be, right? So data is power, right? And then once the data's there, action is necessary, right? So, I mean, it is kind of like, sometimes even I feel like I've been asleep at the wheel, right? Because there's this ROC part of the law that is money that's supposed to be going into the actual communities that were impacted. And this is something that I used to talk about all the time. Like, the Illinois law is so great because it has this money, and it's not just for inside of the cannabis industry. It's supposed to actually help rejuvenate these communities that have been hard hit by the war on drugs by funding nonprofits. Well, guess what? None of that money's been distributed yet at all. And like, I don't even, like, the website is like all one page that says information coming soon, and it's been like that for 2 years. Like, right? Shouldn't we all get mad and call our senators and say, why hasn't ROC started? Can we get that money out there? Like, it's been paid to the state. Let's actually use it. So yeah, I think this is a really good question, one that I don't think I have a good answer for.
Well, that is our panel today, right? Compliance is interesting. I'd like to thank our panelists. Again, my name is Florence Hurdy. I'm representing HT23 Growers, and we won one of the craft grow licenses. So you should be hearing from us soon. But I want to thank our panelists again, and I hope you enjoy the rest of the conference. Thank you.
As you all are having about a 10-minute break, I just wanted to announce a few housekeeping things. We obviously have a 1 o'clock session coming up, and then if you look at your agendas, come 2 o'clock, you have options. Nah. All right.